Sian here? Is she in the room? She's here, isn't she? But she's not like here. I was like, I don't want to start and then. Right, good morning, everyone. Thank you for that rapturous reception. You can tell we've got a group of a lot of academics and others in the room because no one sat at the front. You know, I won't force you all to come down the front. Anyway, good morning and welcome to this event, and thank you for coming today. This is the Journalism in the Courts Symposium, held here at the University of Salford Media City campus. So my name is Richard Jones. We may have not met before until today, but we probably communicated on email or other things. So my job, I'm the head here of journalism, politics and contemporary history. But more importantly for today, I'm the host of this conference. So if you have a question during the day, please ask me. If anything goes wrong, you can blame me for that as well. I want to thank the university and especially the School of Arts, Media and Creative Technology for supporting this event, making it possible, and hosting us here today. Thank you especially to Emma Barnes, Knowledge Exchange Fellow, for all her help in getting today ready. Thank you to everyone here at Media City Building, Estate, Security, Reception for all their help as well. Thank you to our great technical team for their work in preparation for today and during the day, especially helping us with the live stream, which is available on the Quays TV YouTube account, Quays TV, Quays TV YouTube. Thanks to Rob, who's back there. And the recordings of the sessions today will be kept there after today as well. So you can watch these back, share them with others, whatever you want to do with them. I should say, as always at these events, the live stream will pick up any questions that might be asked. Also some photographs and other media will be taken by us, I'm sure by you as well, shared by social media and all that. So just fair warning that there will be photos and stuff today. I also want to really thank the National Council for the Training of Journalists, the NCTJ, for graciously agreeing to support this event as well, including by approaching some of the guest speakers we have taking part today. The NCTJ has got a long history of being at the centre of the training of court reporters here in this country. I know much of what we discuss today will filter down to trainees and students through accredited courses and modules. So there are no fire drills planned today, so if we hear the alarm, it's the real thing, and we need to leave. If that happens, please follow the instructions which we broadcast over the public address system. There are fire exits on this level. One is down that way, and the other one is kind of through the back of the gents' toilets, which is extremely glamorous. But there is a fire exit that way. There are toilets on every level of the building. The nearest ones are straight down there, the other side of the main stairs, near the lifts. When you're coming in and out, please use that door. So I don't want people using that one because it would be a bit disturbing. If you want to get onto Wi-Fi, I'm sure you do. If you work at any university, you should be able to use EduRoam, maybe. But for everyone, there is guest Wi-Fi as well that should pop up for you as well. You probably will need to create an account if you're not already a Sky user. Okay, there are different types of session today. We're going to start off in a moment with a keynote speech. I know we're all looking forward to hearing that. Later on, we've got some sessions which will be formed of presentations where colleagues will be giving us insights into their latest research into different aspects of media law, court reporting, open justice, all sorts of related topics. Some are veterans of this kind of occasion. Others are presenting their research for the first time. So we've got a packed schedule, but we should have a little bit of time for questions in each session. And I know you'll all be as encouraging as possible to our colleagues. At other times, we've got panels, also a round-table discussion planned as well, featuring working court reporters, the Courts and Tribunal Service who are here today. Again, there should be time for questions as well, so please do take part. If you run out of time for that kind of interaction, there's plenty of opportunities to catch up with folks individually and during the day and at the end. We're going to have a lunch break, then there's going to be an afternoon tea and coffee break as well, and at the end of the day, there's a period for networking with some drinks, and that's supported again by the NCTJ, so thank you for that. If anyone wants to keep the conversations going after that, at about 5:30, I'll be heading down to the Seven Brothers pub just underneath us, and we'll be in there for a little while longer. I'm fully expecting this to be a great day full of really interesting conversations here in this room and around the fringes. I do have one ulterior motive for gathering you here today. That is to flog my book. I have written a book. It's called Reporting the Courts, which has got lots of original research in it, exploring the past, the present, the future of court journalism in the UK. Many of the issues we'll be exploring today. These academic books cost a fortune, so I won't be offended if you don't put it on your Christmas lists. But any of you who work at universities, I'd be very grateful if you could put it on your reading lists. Which brings me to where I'd like this to go after today. I'm going to put together a second book about media and the courts and open justice, this time an edited collection of papers presented today, and perhaps some other contributions too. If you're presenting, I'll be writing to you soon to see if you'd be interested in submitting your work to that project. I've found out my editor at Routledge about it, who's happy to see the proposal. I don't think they were trying to fob me off, they seem quite keen. So I'll be trying to get that in quite soon, that proposal. These things do take ages to get approved, and if you work in universities, you'll know all about that. But hopefully I'll get the green light on that by maybe late autumn, and I can give contributors a deadline of maybe this time next year to submit chapters for that. But if you aren't presenting today but have an idea for a possible chapter, again, just let me know, send me over an abstract. Hopefully all in the shops, proverbially. Come in, sit down, come in, by Christmas 2026. I know there are lots of folks presenting today who are former practitioners now working in universities, maybe under a bit of pressure to do some research, think about publications and PhDs and things like that. I hope this plan I've got for a book provides a nice, friendly, encouraging way of getting on with that. Okay, it's time for our keynote speech. I'm very pleased to welcome Sian Harrison. Sian is the co-editor of McNae's Essential Law for Journalists. The phrase industry Bible is a terrible journalistic cliche, but I'm sure you'll forgive me for using it on this occasion, because it really is indispensable. She's been a reporter on the Hull Daily Mail and the Waltham Forest Guardian, spent 7 years at the Strand News Agency at the Royal Courts of Justice, followed by more than 5 years at PA as a law reporter and then law editor of PA. And that's one of the most important jobs in British journalism. Since then, she's worked freelance as a communications specialist, including taking on that co-editorship of McNae. So Sian's very busy, and in fact nearly couldn't come today because a pending Supreme Court ruling might have kept her in London. But I'm very glad the justices have not spoiled our day. And so I'm very happy to be able to welcome Sian Harrison.
Thank you, Richard.
That's all right. Here you go. Just in case people forget who you are, I've got like a slide that's going to remind people of it. There you are. There.
It's good for me to be reminded who I am as well, I think.
There you are.
Thank you very much.
That's all right.
So hello everyone, welcome to this first, I think it is, the first symposium on court reporting.
First and last.
I hope not. I hope it's the start of conversations about this because, I mean, obviously, it's something I'm passionate about. I've been a journalist for 20 years, too long now, and court reporting is something I sort of fell into, and as people do. I was going to start this by saying that I don't think anyone, when they sort of start out, says, when they're like kids and someone says, what do you want to do when you grow up? They say, I want to be a court reporter. But I would like to think that might change. When I first spoke to Richard for his book, which was
2017.
Yeah, okay, a while ago. I think he was quite dismayed, maybe, or by my sort of take on the state of the industry, so to speak, because I was fairly negative. I think it's safe to say I was, dealing at that point. I was at PA, I think, and I just started at PA. And I was, coming up against the problems that we have, the challenges we have on a daily basis. And so, I was quite sort of downbeat about the state of things. But I also said there were green shoots, and there remain some green shoots. And so I'm going to sort of sum up where we are now, and also mention some of those green shoots because it's important to be positive. Court reporting is largely unchanged since the time of Charles Dickens, who did actually sit in the Court of Chancery. And, in terms of the input, so it's very similar to what he would have done sitting there he apparently had excellent shorthand, which is why he was in demand as a reporter for that kind of thing. And it's the same kind of job. You sit there, you listen, you take a note, and then you file a story. But now the output is very different. I think there's, we're going to be hearing about the methods that people use to tell those stories from the courtroom and beyond. And I think that it's important that we are aware of the changing landscape of media, but, court reporting seems somewhat archaic in that sort of sphere, but it's really important, and I'm hoping that I don't need to persuade anyone here how important it is. But I think we all have a job to do to kind of inform the general public. The first time I ever set foot in a Crown Court, I was doing work experience at the Hartlepool Mail, and I was taken to Teesside Crown Court in Middlesbrough, and it was the case of a woman called Sian Harrison, who was convicted of, that day actually, we were there when the jury returned, and she was convicted of murdering a child who was in her care. She was a babysitter. And I will never forget the kind of howl of pain she let out as she was convicted and the jury returned the verdicts of guilty. I think that, for me, was a kind of crystallising moment, because I sort of realised the lives that, you're dealing with as a journalist when you're in a courtroom. You're hearing about tragic events and you're seeing people's lives changed. Sian Harrison, years later, was actually cleared on appeal. She had been wrongly convicted, and the fresh medical evidence, kind of cleared her of that crime. So that's another thing that I will touch on later, because later in my career I've been dealing with miscarriages of justice, and the one that Richard mentioned that meant I might not have been able to make it today is the case of Tom Hayes, and I'm now dealing with his case from a kind of media consultant point of view. But the principle is the same, that we are telling people's stories. We are dealing with them often at the worst moments of their lives, or certainly reliving the worst moments of their lives. I think it's important to think about what court reporting is, and that might sound very basic, but it's not something that we sort of just take it for granted, really. You just go to court, you do your job. But it's actually a real kind of skill, and also it comes with lots of difficulties. You are in the courtroom, yes, but you are expected to kind of go beyond the courtroom. You're telling the story, you're recreating the scene of a crime. Sometimes you're dealing with people's, kind of, like I've said, the sort of worst moments of their lives sometimes. I mean, I'm focusing on criminal, but obviously there are civil cases as well, and I, have covered plenty of those. I went from the Hull Daily Mail, as Richard said. I was the court reporter there for about a year, and then I moved to London, and I worked at the Royal Courts of Justice, where I covered many cases that are often cited, I think, in kind of precedent-setting ways. But the job is essentially the same. You have to kind of also deal with people outside of court, and that's an important part of the court reporting. You handle those things sensitively and with great care, and I think it's a responsibility people take very seriously. It's also important because it's part of our democratic structure, right? So people want to know what's happening in their courts, yes, but also the judiciary is the third pillar of the Constitution, and there's a democratic kind of role and function there in reporting what the judiciary is up to. And I think that's kind of an underplayed thing. I was sort of dismayed, although I understand there are reasons for this, and it's probably being negotiated behind the scenes. But I was a bit dismayed that Tim Davie didn't mention court reporting when he spoke recently about the expansion of the local democracy reporting scheme, because it is vital, it's crucial for our democracy. It's as important, I think, as political reporting, and there's way too much of that, in my opinion. The sort of, like, politics has dominated a lot of the news agendas, and to the detriment of other things, I'm sad to say. And I would like to see court reporting kind of on the same footing, on a level footing with political reporting, and recognised as the same kind of level of importance. And yeah, like also people do just want to know what's going on, and people like a bit of gossip, right? So I think the biggest sort of example of that I've come across was when we covered the Johnny Depp trial, which was July 2020, so the height of lockdown. I think we're just coming out of lockdown, pubs were open again, thankfully. And the trial was him, just for anyone who has forgotten that whole period of time, he was suing the Sun for calling him a wife beater, and he lost his case. But the massive level of interest in that actually drove sales at PA, and they put on, like, I don't know, a bunch of customers. We won an award for it, so I assume it was quite lucrative. But it was, you know, it just showed that people are really interested in what's going on in our courts. And, you know, he's obviously a Hollywood star, and that doesn't come around every day. But courts do deal with absolutely everything. I have a slightly unfortunate nickname for the Royal Courts of Justice. I uncharitably referred to it as the dustbin of humanity because literally every kind of case you could possibly conceive of came there, you know, people like rulers of countries, divorce cases, terrible tragedies where children are injured at birth, kind of people suing over like long ago events like the Hyde Park bombing. These are all like really important things, but it just demonstrates you have the whole variety of life. To paraphrase Samuel Johnson, like, when one is tired of the law courts, one is tired of life, I believe. And I'm sort of still floating around there now and seeing, like, fortunately, someone else is doing the job that I used to do up here, which is very kind of hands-on and knowing what's going through the dustbin at any given moment. But I can kind of, like, now just float around the top and watch other people be in that stressful position. But I'm still have my hand in on court reporting, which is good. I think that pandemic really revolutionised court reporting in some ways. Obviously, things had to be very hastily put online, and that just all happened in about a week, which is really quite remarkable when you think about it. But some of that has stayed with us. There are still sort of remote hearings, and people have realised that you don't actually have to be in a physical courtroom, and that the virtual one works just as well. So that's, I think, a good, positive thing. Few issues with people not fully appreciating that their laptop is now the courtroom, and you know, taking photos that they maybe shouldn't have, that kind of thing. But generally, it's been a sort of good thing, and I think AI will revolutionise things in the same kind of way. I think it will be a massive change, but I don't see that it will ever really be able to replace court reporting. I don't know how. I know that there are some technologies out there where they can kind of produce, like an AI can produce a court report. It's pretty good, I've seen it, and it's a bit scary, from essentially magistrates' court lists, that kind of data. But I don't see that as being a replacement for somebody with the human aspect, kind of going around speaking to victims, all that extra stuff, and, you know, being fully accurate, fair in everything. But I think it will enhance what we do, because I think there are lots of things going uncovered that we don't know about at the moment, because we just, as you know, Richard's book has highlighted, we don't have enough court reporters in England and Wales. I think it's good that we have some, but never enough. There's never enough. I think I just want to talk about some of the challenges of it. It can be difficult. Sometimes you have to be able to stand up at a moment's notice and challenge a spurious reporting restriction that someone's trying to stick on a case. I was covering the case of Andrew Malkinson 2 years ago and hadn't anticipated any kind of difficulty. But the CPS barrister stood up and said, I'm going to ask for a postponement order. And I can see, you know, as tends to happen if you're the PA reporter, all the other journalists sort of look at you. I could see people's eyes frantically kind of, you're going to get up. And I did have to just sort of scramble to my feet and say, absolutely not. Please, don't put anything on this case. It's been widely reported and, you know, there's absolutely no point in sticking an order on it. Fortunately, the judge agreed with me, and so did Andy Malkinson's barrister, by the way, so that made my job a lot easier. But yeah, you have to be prepared and you have to kind of know this stuff. And it's not a shameless plug for McNae's Essential Law for Journalists, but it is really, you know, a vital tome because people can just flick to the relevant bit and say, hang on a minute, you know, can we think about what we're doing here? Sometimes it's not successful, but, you know, it's at least makes it possible. The other sort of main challenge is, well, the emotional and mental toll, frankly. And I know that we've got a panel later on today dealing with this, and I think it's really important. It is not easy to sit in a room day after day hearing some of the worst things about humanity. When I was at Cardiff doing my training, and I see Sarah will remember Duncan Bloy very well. He was our law lecturer, and I'd gone to him for some advice about an essay I was doing on contempt, and I was talking to him about Levi Belfield. We were just having this chat, and, you know, horrendous case. And I was actually saying that my dad had been very concerned about me going to London shortly after the murder of Amélie de Lagrange. And I had to explain to my dad, London's pretty big, you know. I didn't tell him I was actually staying in Twickenham, not near the Common. But, you know, that is the kind of thing that we carry with us. And he said something that was really important, and I've kept it well in mind throughout my career. He said, out of the millions of exchanges that take place between people every day, you will be dealing with the 0.001% that go wrong. And it's really important to keep in perspective. But when you are sitting listening to horrific child sex abuse cases, murders, terrible things that happen, it can really sort of eat away at your soul. And I have, you know, great strides have been made. It's only recently that we thought it might be a good idea for juries to have counselling. And I think it's also critical for court reporters to have proper trauma-informed therapy. And it's something that I advocate for through various, you know, committees that I sit on and what have you. But it's, you know, it's not easily done. It's not a light job. And I think we need to acknowledge that and confront the problem head on. Good news. I'm going to come to the good points. Things have changed quite a lot since I started as a court reporter. Very positive strides have been made towards transparency and open justice. Yes, there are constant battles with reporting restrictions, and we're constantly kind of, you know, keeping that pendulum swings, and we try and keep it, you know, relatively on the right side. I think Richard mentions in the book that I was terrified when I was a PA that we would just miss some wholesale challenge, and fortunately my former colleague Sam Tobin spotted one with the Babita Rai case, and we managed to prevent like a blanket ban on addresses being given, mercifully. So, you know, that those things do come up and they are difficult. But I think we are now in a state of generally increased transparency from where it was when I started. The family courts have opened up. I think that they're really not very well understood, and the reporting that comes out of the family courts there's been some excellent reporting come out of the family courts, but it tends to focus on things when they go really badly wrong. There are some really great things happening in family courts as well. And I think that now we've been given the chance to go inside and see what's happening, and the presumption has shifted. So before, when you were in a family court, you could sit there, you could take notes, you could see the papers, but you couldn't report anything without express permission to do so. And now it's the other way around. So you can, unless you're told you can't. That is a massive change. I don't think you can underestimate, overestimate, I'm not sure which one, but I don't think you can say enough, like state enough, how slow to change the kind of justice system is. I can see Celia nodding, she agrees. It's like trying to turn a tank. Do you remember that Bibby Stockholm that got stuck in the Panama Canal? I think it very much feels like that. Nothing happens very quickly. Just a quick sort of anecdote, example of, I guess, the slow snail's pace of change. In 2010, when there were huge cuts to the Ministry of Justice budget, that meant that practically there were no documents in court anymore. So in civil courts, you don't really hear what's going on. It's all been reduced to skeleton arguments. And if you don't have those, you can't follow what's going on, because people will literally stand up and say, my lord, I direct you to paragraph 5. Here are my legal arguments, and you don't know what the case is about. So we were suddenly completely stopped, really, from finding out what was happening in courtrooms. And some of my former colleagues spent 2.5 years getting one practice direction that applies only to the Court of Appeal Civil Division. That shows you the kind of glacial pace of change we're dealing with. But things have changed really quickly as well. So they can do it when they want to. We've got cameras in courts now. I thought that might never happen. I think when I first started working at the Royal Courts of Justice, they had just put in a pilot scheme in the Court of Appeal, and it went on for years and years, and nothing more happened. And then suddenly, we have judges giving sentencing remarks on cameras, and it's made a massive difference. I think it's impossible to kind of overstate the importance of the public education role that court reporting plays as well, because, you know, public understanding of the justice system is patchy at best, and it's, you know, it's crucial that they understand what's happening for all kinds of reasons. And I think the cameras in courts and the fact that we can see judges and they're explaining their decisions on sentencing is a really massive step forward. And there's work being done, I believe, to kind of try and increase that where possible. And then we have this huge transparency drive that's being driven by the Lady Chief Justice and Mr. Justice Nicklin. Again, slow to change. You know, we've had some meetings, we've had some discussions, not a lot feels like it's happening, but things are improving. The documents I spoke of that are so crucial to court reporting are now there's a pilot that they're being put online. I mean, we've been saying for quite some time that should happen, and it has been done in 2 cases only in the Supreme Court, both of them about Brexit. But, you know, that's now happening on the Court of Appeal Civil Division website. You can get the documents for the case. So it's not just good for court reporters, it's good for the public to understand what's happening in their courts. And, you know, that's not going to replace court reporters either, because I think people would much rather have a sort of potted version prepared by a skilled person than sit through an entire day's hearing and read all the documents. I think I'm just going to round up by saying I would like to use this opportunity to make a real plea. I think we should have more court reporters. I think we should have people saying, I want to be a court reporter when I grow up. And I think we should take care of them as well. We should really look after the people who sit there raking through the difficult things and bringing us the stories of life. Thank you very much.
Great, fantastic. Thank you, Sian. Right then, so we're going to have a break for a couple of minutes just while we set up for the first panel. If you've come in, and there's lots of people coming in at the back, there's loads of seats down the front. Sorry, there are loads of seats down the front, so you might have to sit down the front. There are some spare ones of these too. So I'm going to chair the first session. So if you're speaking first, that's Fran's group, Sally, Brian, and Amanda. So if you want to just come up to the front and sit in these, and I'll call your presentations up. We'll get going again in a couple of minutes. Come on, do pass some back. There you go, for some at the back. So we've got a series of presentations now, which are going to be on the theme of issues in court reporting, and I'll introduce each one as we go. There may be time for a question after each one, but also we may have time for a question or two at the very end. But if we don't quite have time, then, well, I guess we'll see how we get on. Anyway, I'm going to introduce, first of all, Fran and Tom, who are here for Liverpool John Moores, and they're going to kick us off.
Thanks, Richard. Hi everybody, my name is Fran Yeoman. I run the journalism department at Liverpool John Moores University. I'm going to hand over to my colleague Tom in a second, but before I do, I'm just going to open by saying that it's some punchy scheduling, I think, of Richard to put up first in front of a room full of court reporters, a paper which is ostensibly anti-court reporting. And I'd like to start by saying that it isn't. I used to be a court reporter. Some of my best friends are court reporters. And this project actually stems from my horror, actually, going to a symposium with some young people whose parents were in prison about their understanding of court reporting and its purpose and their relationship with it. And I was really interested in what Sian was saying about court reporting being about real lives and being about people at sometimes the worst moment of their lives. And there are also people who are not actual players in the court cases for whom that is also true. And that's what I think this project, which is an ongoing project, is about. The artwork there, by way of explanation, was created by two children at an art therapy class run by our colleague Lorna Brooks, who runs an organisation called Time Matters that supports families who have parents in prison, and that depicts for them the pain that they're going through from having a parent in prison and the exacerbation of that from seeing their parents' cases reported in court. So that's just what that is. But as I say, this is about trying to build bridges, develop awareness, mutual understanding, and exploring their perceptions and why they have them. And with that, I'm going to hand over to Tom.
Okay, so just quickly to introduce you to how the study came about. So Lorna Brooks from Time Matters, you know, the children and families reported the distress about what was written in newspapers and shared on social media and how that impacted their lives. And we all know in the room of court reporters how important open justice is, but also as well as just looking at how some people might not necessarily understand the process of what's going to happen in court, because you know, we're used to it, we do it all day, every day is our jobs, and it's never happened to these before. So they told Time Matters about community backlash with sort of like people knowing what's going on, people not wanting to go to school or college, you know, this has happened to your dad and this is your family, this is your home, etc. There were alleged inaccuracies, untruths, and inaccuracies, untruths, and sensationalism, which I'm sure many of you have dealt with before. We've all been approached by people when we've been in court, and you know, different viewpoints, and we know what we're trying to get across, and we know what we're allowed to report, and you know, people sort of have their own views on that, and then non-offending family members self-isolating in their homes or wherever that is as well. So, with funding from the Merseyside Violence Reduction Partnership, which basically does what it sort of says on the tin, it is an organisation aimed at reducing violence. There was a focus group with children who have parents who are in prison or have been imprisoned, and with non-offending partners and family members. So then what we did then was one-to-one interviews with journalists, regulators, union, and also then we did a content analysis as well over a period of 3 weeks, looking specifically at court reports where someone had been sentenced to imprisonment and their parental status had been mentioned in the report as well. So it's quite specific area stories we were looking at.
So this is just to give you a little bit of a flavour of what some of the children said. Their perception very much is that the court reporting and things being published in the mainstream media specifically is making their lives worse. They have a particular issue around addresses. They feel that the publication of an address, which we know is there to avoid defamation and is standard journalistic practice, they see that as making them vulnerable in their homes. And in fact, not in this focus group, but in the initial session that I went to that made me interested in this project, they talked about it being a deliberate act to shame them. You know, and that's about understanding, and I think that should be maybe concerning to people in this room, that the understanding of why things are done is the issue. This is not that what they're saying is necessarily accurate, but this is a big cohort of people who are directly affected by what we do, who perhaps don't understand it enough. So you can read some of those for yourselves, but again, to sort of, I think, to your point about this being the worst time in people's lives, sometimes, you know, they think they're just reporting a crime, but something terrible has happened to our families, and they're just making it worse. Issues at school, and then again, this issue of Googling and things being online, you know, potentially for much longer than they would have been, you know, just in a print newspaper back in the day. The non-offending adult group that we spoke to, so this is parents, you know, partners and so on, you know, the parents of the children who aren't the one who've gone to prison, and also people who are now adults who, as children, had their parents' crimes reported on. Again, ideas of sensationalism, things not being true, you know, the shame, issues in school, and then again, for one young woman who's since grown up and gone for jobs, reporting that employers are, you know, Googling her name and finding sort of copy about her family's crimes online. And this is, you know, a small group, not necessarily representative of that. There are hundreds of thousands of children in the country with a parent in prison. There's, you know, this is not a niche community, but if we're thinking about these people and their families and their relationships with court reporting, and by extension then journalism in general, there are clearly some sort of challenges in terms of perception and particularly a sense of sort of persecution, I think, was strongly what was found in that focus group. Moving on then, this is probably familiar to most people in this room, but we interviewed some specialist court reporters. We spoke to the NUJ Ethics Council and to IPSO. The findings there were, and I should say also that this is a work in progress, and we would really love to speak to other people who feel that they have things to say on this topic, ideas for what could be done to build bridges, all of that. But so far, in terms of the interviews that we've done, there is sympathy for these families and their perceptions. You know, court reporters are not monsters, and you know, the people we spoke to understand that is a challenge, but the challenges that they're facing, but stand adamantly by the principle of open justice and the important social function of court reporting, and that's probably not a surprise to anybody here. They made the point that addresses are important to avoid defamation. Also, this idea of that the young people spoke about, like, why do they have to say mum of 5, dad of 3? Why do they have to bring me into it? What the court reporters told us was that's often done because it comes up in mitigation in court. Not very often are reporters going out and looking for that kind of family information if it isn't raised in court. And if it is raised in mitigation, then it is you know, relevant to the story in terms of, you know, why somebody might not have got a particular sentence. There was support for the idea of more advice for the families about how the system works and explaining the principles and practices of court reporting, but absolutely no interest in more rules or restrictions on open justice or transparency. And they also made the point that a professional court report, an accurate, ethical report of a court case can be the best bulwark against coverage that will be there anyway on social media from amateurs in the current climate, and that in fact we should be trying to encourage court reporting to be seen as a way of getting your story out there accurately, even if, you know, the reality is these young people, a lot of them would like to just shut down court reporting altogether. They would much rather, you know, that it wasn't done, and that, I'm sure, is a position that nobody in this room would support. So can we persuade them instead that court reporting can be an ally if it's done well? Just very quickly then, before I hand back to Tom, these are some of the quotes from the interviews that we gathered during the sort of media industry phase of things, just backing up those themes that I articulated a moment ago. Do you want to pick up?
Okay, so and then we looked at the content analysis, where basically the way we did it was I looked at the ABC figures for what were the most read free-to-access national titles and regional titles, and Human H being the most read free-to-access were also the most read. And over a period of 3 weeks, I was looking for articles which were specifically where someone had been sentenced to imprisonment and a parental status was mentioned. So there were 186 of those across the Mail Online, The Sun, Manchester Evening News, Liverpool Echo and Birmingham Mail, with the biggest traffic for the regional titles. You can imagine my news diet for 3 weeks was exclusively pretty harrowing court reports, so that was fun for someone whose bread and butter is sports reporting. So the figures said 155 about male offenders, 17 female, and 14 were about both male and female offenders. And out of those 128 included some form of address. It's important to note this wasn't full address as well. That never came up where there was a door number, a street number, and a location. It was usually an area, sometimes a street address, never. I think there was one where the name of a pub was mentioned, so you could work out which building it was, but that was it. So the overall picture from court reports was actually one that was quite restrained, really, in terms of like the address was there to serve the purpose of what was said about defamation, but it was never a full address. 32 of those referred to an offender's parental status, and 24 of those included some address details. So again, an overall picture of which there's a little bit of inconsistency in what was said about an address needed for the purposes that were said, because some articles didn't include any at all. And 12 of those references to children where the child itself was the victim, which obviously, as we know in this room, means that is integral to the story. So there were instances where it was unavoidable, and 20 other stories in where parental status of the offender was mentioned where the child wasn't the victim or involved in the story another way other than if it was mentioned in mitigation, but that isn't mentioned in the court report. So there's not always a way of knowing why that parental status was mentioned. And even though we all know in this room that it was important to check as well that there were no instances of photographs of family members other than where the relative was the deceased victim. So again, things like photographs only being used where it is relevant to the story. And there was no occasion where a child's name or age was included, again, other than when they were themselves the deceased victim. Okay, so like we said before, it is a work in progress, but what we realised from everything we got together is, court reporting doesn't necessarily need to break the law or any codes to have a negative impact on innocent people, so non-offending family members or children of people who are sentenced to imprisonment. And the children who come into contact with the criminal justice system in many contexts get protections, but if open justice is to be the defence of these impacts, do we need more consistency maybe around addresses and things like that? Or can anything be changed to preserve the openness of court reporting while mitigating these impacts? So one of the things that we're looking at maybe is, the way we communicate with people. People don't necessarily always know what to expect when a family member is going to court, for example, or how the media necessarily operates. Some of these people have never been to a courtroom before, so don't understand, or probably a better way of phrasing it is aren't necessarily familiar with the processes for why we do what we do. And I think a lot of that could just be opening lines of communication. Sometimes people might feel less affronted or less victimised if they know that what the process is going to be. Have you anything else to add, Fran?
I mean, loads, but
Yeah, but yeah.
We'll leave it there for now.
Yeah.
If there's any questions at this time, either on Richard's time or later, we really would. We're really grappling with the what's next question and what can be done to square this circle. These young people we described by one of the reporters who spoke to us collateral damage, like not in a mean way, but just in a the reality is open justice has costs, human costs, and these young people are one of those costs. And just is there anything we can do while being true to what we all believe as we're planning for more reporting to make life easy for them? And if anybody's got any thoughts on that, then we'd love to hear from you.
Right, I was going to call up Sally's presentation, but if anyone has a quick question, fire away. Yeah, Celia.
One of the amateur reporters that you referred to puts court reporting on social media. One of the things, we have a similar problem in court protection with families being really upset that we're reporting on them. We try to be really sensitive in our blogs and not include all sorts of things we think they might not want. And then the judge publishes the judgment. And it's all in there. What happens in these cases? Is there a published judgment with all this kind of detail in it already?
So I think that's a really interesting point, and you talked about the increasing publication of court documents online as well, and that I think not for somebody such as yourself who's here at this conference and clearly thinking about this stuff really hard, but the wholesale publication of documents relating to court cases will have downsides in human terms for people who were mentioned in those documents. Even if not by name, that's more and more information for these more and more information about their private lives that anybody can find. A court reporter, an ethical court reporter, might decide to leave some of that out. Somebody who's having a Google isn't necessarily going to do that. So there is a whole question there, I think, about the whole self-publication of information online. But I think that, amateur or citizen journalism is one thing. There's just the general circulation of gossip and swirl about such a body's house being in court is equally, that's not a report of any kind, but that is there. What these young people, like, they're not going to be able to avoid information reaching the public domain about what has happened to their family members. So the question is the differentiation. Well, A, the court reporting is always doing its job as well and as ethically as it can, but B, then the bridge building and the awareness raising and giving them some kind of sense of agency, so that, I had a row with them basically for about 2 hours when I met them. They were like, I can't believe you do this just to put like food on, a fancy meal on your table. Like, firstly, do you know what we get paid? But secondly, that's not, it was a really difficult conversation. At the end of it, they all came over and said thank you, and the non-defending parent came and said thank you. We understand things more now. Thank you for talking to us. Thank you for taking us seriously. So I don't think anybody's going to rewrite court reporting in a way that makes them go, all right, then that sounds great, let's do that. But you can at least give them maybe some sense of agency and some sense that this is not about persecuting them. That's what we're...
Great, thank you very much. Again, fun. So, we're moving on now, and I'm pleased to welcome Sally Reardon.
Hello, everyone. So I'm representing my colleagues. We work across law with 2 lawyers and 2 journalists. I'm one of the journalists, and Bernard is, and we work out of Bristol. And we've been looking at court reporting over the last few years from a state of the art, if you like, and how things evolved during COVID. And over the last few years, we've been looking at this sort of new phenomenon, as Sian mentioned, televising sentencing in courts. Just thought I'd start with a quote from Dominic Raab, amazingly. Opening up the courtroom to cameras to film the sentencing of some of the country's most serious offences will improve transparency, reinforce confidence in the justice system, and the public will be able to see justice being handed down, making them understand better the complex decisions judges make. And I think we need to keep that in our head as I talk, because our question, I suppose, is, does this work in terms of filming court? And today I just want to look at the last 3 years, some sort of overall trends in the type of stories or types of cases that are requested to be filmed, and some of the ways that the footage has been used, mainly by broadcasters I'm talking about today, and the system of monitoring this, which is not necessarily as good as it could be, and then to think about what the next steps might be. And I also want to ask you what you think about the development of sentencing, because it is almost unique that Richard has managed to gather this many court reporters, this many researchers of court reporters, and this many teachers of court reporters in one room. So I'd be really interested to hear what you think about it, what your experience of this phenomenon has been. So, again, John Battle, at the end of the first year, John Battle at ITV said, this has been a fantastic success and has swiftly become the norm. And when you think that the first year, 33 cases were filmed. And now I don't know how, I haven't got to hand exactly how many cases appeared in Crown Court that year, but it was a lot more than 33. And there is this assumption that by merely filming in court, that this is an automatic good. So, just in context, that cameras are, the possibility of open justice, more transparency, has been moving forward. We all know about court reporting restrictions, make it very tricky, but cameras have been slowly creeping in. We've got the Court of Appeal, Supreme Court is televised, and now we have sentencing in Crown Court. But it's for those of you, I'm sure you all know this already, but only 4 organisations can request to film at the moment. You need to make an application, and the Crown owns the copyright of that footage, and that it should all be deposited on a Sky court channel. I'll put the link there if you want to watch a lot of really hideous sentencing remarks. So it kicked off in, the first one was July 28th in 2022. And so we've been looking at the types of court cases going on. As we say, we want to test whether this actually meaningfully contributes to things. So first year, 33 cases filmed. There were 36 requests, but 3 of them were turned down because of they didn't comply with the rules. You find that out through an FOI. And then the second year, 31, and this year it's nearly finished. We've got another month to go. So far, 43. Although I have not included the aftermath of the Southport kind of riots, because there were a lot of those cases, and I sort of think we should put them to one side slightly. Huge number of cases, 28 across the country, England and Wales, from Merthyr to lots in Manchester cases. So it's quite wide, and of course, I'm sure we've all seen this locked off mid-shot of a lawyer looking slightly off camera at someone we never see. Some of the sentencing have been very long, over an hour and a half. Some of them are very short. The second Letby sentencing was only 5 minutes. So they're quite varied. But what you also notice, and I'm sure you've been watching them, they sort of drop out. The video and audio sometimes drop out because there are court reporting restrictions. So if you watched, who watched the Letby sentencing? Yes, nobody wants to. You notice it, the audio disappeared because to protect the identity of the families and the victims. So they're not entirely transparent, if you like. The kinds of cases, the news values, no surprise here that it is about the most serious cases, but they're all about murder, generally. I would say 95% of them involve somebody dying at some point. There are some sexual offences, but the only ones that really get televised are the ones in which there is a person of authority. So if it's a former police officer or a serving police officer, or there's a case of a prison officer who's having sex with prisoners, that made it into the requests. I know these, you're right, the horrible things we look at. And then there's a little sprinkling of espionage and terrorism, case of organ trafficking. So they are a lot of the cases involve a lot of extreme violence. So again, if you're sitting down to watch these, we had a researcher, a student who had to watch a year's worth, to have her looked after afterwards. And there's an awful lot of stranger danger kind of cases, and probably more over-representing stranger danger cases compared with what actually happens in the world. A lot more, and there are a large number of people who are killed by people they know. And of course, they're only there because they're already reported. You don't get a sentencing request unless you've already been following the case for a long time, obviously. The victims, if you look at over the last 3 years, it's dangerous to be very young or very old, although 61 plus is not old, obviously. If you're in this bracket, this is the safest age to be, it seems. But as you can see, that there are a lot, I mean, again, this is obviously a news value, that the vulnerable victims are more likely to make news. Again, it's, even without the Letby victims, there's still an awful lot of child murder if you watch these kind of cases. In fact, it's incredibly rare, but not in terms of coverage. And then what did people do with the footage? The broadcasters, this is from the first year. We haven't gone through everything of the last 2 years. But the first year BBC used about 3.5 minutes across the year. So most clips, 60 seconds was the longest one. Some were like 5 seconds. This is only in the bulletins that we looked at, the main evening bulletins. Obviously, there is now an increasing use of live streaming the cases. As someone who worked at Sky, we always loved it if there was a great big live that you could run all afternoon and didn't have to do anything else. but as I say, there's very little used in bulletins, so unless you're watching Sky TV or streaming on your phone, you're probably not watching this sort of stuff, and you're not even seeing it, because there were lots of things that were filmed but never made it into bulletins at all. So, you know, the first year, I would say, it's not surprising, these were the most serious cases. The use of them in footage in bulletins was very limited, and I think that they don't really replace the reporter standing on the steps of the court explaining it to you. The static camera in the judge, of course you don't see anything else, and even in the coverage, I was looking at one the other day in which they said they'd edited the sentencing remarks because there was a disturbance in the court. So even if someone does try and shout out anything, they take that out. You can only see the judge. As I say, there's a limited choice of cases, but not surprisingly, they do tend to be the most serious, dealing with the most vulnerable. And it was quite an enthusiastic use of the footage at the beginning of the year, but by the end of the year, we felt that the novelty had worn off, and people were much more interested in using dramatic pictures of arrests, because that's more interesting than a man or a woman staring off camera and talking. Then in year 2, just outside the first year, Lucy Letby came along, and that kind of changed everything. I feel that this is what the broadcasters had been waiting for, a case of such magnitude, to be able to see the judge. You know, we all watched it, and I remember the judge saying, "You will spend the rest of your life in prison." And my fellow researchers and I kind of went, oh, there's a little bit of a kind of frisson went through the room almost. This is the kind of thing that we've never seen before. And I think that recap, and obviously it ran live, it was huge, it was a kind of added to the coverage, I would say, and perhaps added to the transparency of what's going on. And then year 3, so there were fewer televised cases in year 2 than there were in year 3, but in year 3 I would say things have started to pick up. There's like 43 cases, not including Stockport. But Stockport, well, not Stockport itself, but Southport. The rioting that went on across the country in early August last year meant a lot of people got arrested, and suddenly you saw a lot of sentencing remarks. Now, these are not the most serious offences. These are kind of criminal damage, assaulting a police officer, writing racist crap on social media. Now, there were lots of them televised, but there's only 11 on the Sky site that I found. There are more. I found a couple on Manchester Evening News site, which are not being archived onto the Sky site. And I kind of feel at this point, there were a lot of low-level cases, but collectively, they became a very serious story together. And it kind of shifted, I would say, the narrative of why we were seeing this. Because it sort of collectively, I feel, was serving as, it almost felt like it was serving as a warning. You go out and riot on the streets, then this is what justice will be served immediately within that week, and don't you do it again. It kind of, I don't know what other people, again, I'd be interested to hear what you thought about it. And it sort of made it from the kind of outliers of the evil Lucy Letby, kind of, who was over there, not like anybody else, to the kind of, it was the man on the street doing this, and there was a lot of footage of that. But rather worryingly, it's not archived, and I don't know where a lot of it is. And of course, there were lots of other sentencing that went on that were magistrates, and since we can't film magistrates, we don't see any of that. And things like, I was looking for the Mike Amesbury case, but of course that wasn't magistrates, so we didn't, because that would have been a bang to rights. And the other thing that I think that we need to think about is the camera angle issue of this very boring shot. There's been some interesting footage, interesting research in which how people respond to these kind of shots. So if you just have a camera on the judge, and you just have a camera on the defendant, if it's on the defendant, they tend to the audience tended to kind of dislike the defendant more and more and distrust them. But the same thing was true if you had the camera on the judge, that people looked at it and kind of, he looks a bit dodgy, I don't know whether I believe them. So this is not a neutral shot. This needs to be thought about. So we need to do some more FOIs to find out how many cases are out there so that we can get a proper understanding of all the cases. We need to kind of be on it about whether the Sky are putting their footage up as they should be. And we need to do a bit more work about how the footage is being used by broadcasters and other outlets. And of course, there is a what do the audience think about this? Has the audience been miraculously educated into how the sentencing system works? And what's going to be filmed next? Because I know the broadcasters want to maybe film summing up, legal summaries at the end of cases. That again, we need to think about how we shoot that in terms of public understanding. So, conclusion, does it meaningfully contribute? I think there is a valid point of having this. It does allow people to go and hear what judges have to say, which they haven't done before. But the fact is that most people don't see this because it's not used. It's clipped into a dramatic grab at the end, and that's it. I think transparency is a more complex thing than just simply showing something on the telly. But at the same time, I also think that maybe there is perhaps some kind of potential for increasing people's kind of trust if they can see things, as long as it's not redacted all the way through. So I'd be very interested to hear, if not now, because we're probably running out of time, but what you've seen in your course of your work about whether it improves or what's benefits and drawbacks. And that's all I've got to say. Thank you very much. How many minutes that was?
Fantastic. Thanks. Yeah, we are running a bit up against time, so I was going to, if you want to call Sally later over lunch or any other time, that'd be grand. So what I want to do is I'm going to call up the next presentation. So Brian, is it? Here we go. So I'm really pleased to welcome Brian Thornton, University of Winchester. Brian.
Thank you. I feel like I should declare that I am not a court reporter, but I very much like them. And my presentation, which should be pretty short, is more or less praising them and thanking them for their work, because it has enormously helped my work. So this is me. This is a grab from one of the documentaries that I was involved with. So my area of interest, my area of research is miscarriages of justice. So I set up the Winchester Justice Project. It used to be called the Innocence Project, but then the Americans wanted us to pay. So I said, no, I'm going to rename it. So it's the Justice Project. So that was quite a long time ago, 15, 16 years ago when I set that up. And my cases, some of my cases have been featured in documentaries and in newspapers and in various other places. I was interviewed for a series on Sky about one of my cases. So that's where I'm coming from. And I'm just going to talk about how useful court reporting is to somebody who's interested in miscarriages of justice, for a reason that I think might surprise you. But before I get to that, I just wanted to give you a little bit of context, a little bit of background on how criminal appeals work in this country. So journalists, and we should pat ourselves on the back for this, have a very noble history for helping people who have been wrongly convicted. So a well-known journalist called Arthur Conan Doyle, I'm claiming him as a journalist because he wrote about these cases in newspapers. He championed two cases, the George Adalji case and the Adolf Beck case, and it was because of pressure that he exerted because of his campaigns to expose these miscarriages of justice that we have the Court of Appeal. I'm simplifying that, but it was broadly the pressure brought by these cases that we have the Court of Appeal. So that was a big deal because it was the first time that there was a recognition that the criminal justice system, or particularly the juries, make mistakes, something that we kind of take for granted now. And the only reason that we know about cases like the Birmingham 6 and the Bridgewater 4 and the post office scandal is largely because of journalists. Because one, we know about them, but number two, they found justice broadly because of campaigning journalists, investigative journalists, and court reporters as well. The quote here is from a kind of legendary barrister, Mike Mansfield, who said, "I believe the force that shook the long-standing entrenched bastions of the law was the power of investigative journalism." And he was talking about really the investigative journalism of the kind of 1980s and 1990s because of this pressure that came from these cases that originated really in the 1970s and 80s and 90s, we got something called the Criminal Cases Review Commission. And so the idea was, again, because of journalists, we got the Court of Appeal, and because of journalists, we really got the CCRC. And the idea was that this would be another safety net for people who claimed that they were convicted wrongly. So the CCRC was started business in 1997. The idea is that it is independent. It is obviously funded by the Ministry of Justice, but it is supposed to be independent. And in order to apply to the CCRC, you have to be convicted. And you also, I'm afraid most people will not be eligible here, but you have to be convicted and you have to have exhausted all avenues, i.e. that you must have failed in your appeal. So if you are convicted and you fail in your appeal, you can apply to the CCRC and effectively say, I am an innocent man, I am an innocent woman, and I want my conviction to be looked at again. The CCRC, as a body, what it's supposed to do is investigate criminal convictions, convictions in England and Wales and Northern Ireland. It will only look at applications that have what it calls fresh evidence. Fresh evidence in the terms of CCRC is evidence that wasn't available to the defence at the time, and that is either evidence or argument. It has the ability, has the power to refer to the Court of Appeal. So you are convicted, you fail in your original appeal, you apply to the CCRC. The CCRC is very much won over by your arguments, and then they refer your case to the Court of Appeal. But the CCRC will only refer to the Court of Appeal if it believes that there is a real possibility that the Court of Appeal will quash your conviction. This is a very high bar, very high bar. And you'll see this from the final point. Last year, there was a record-breaking 1,629 applications to the CCRC, and there were 25 referrals to the Court of Appeal. So this is a room full of journalists, so I don't expect anybody to do the math on that. Journalists and maths is like water and electricity. So I've done it for you. It's like about 1.5%. It's tiny. So broadly what happens is, the numbers vary over the years, but generally the CCRC will reject 97, 98, 99% of applications per year. I've worked on miscarriages of justice cases. I've worked on about 6 cases so far. Trying to overturn a conviction in this country is really hard. It's really hard. There's a few people nodding, so maybe you've been there as well. Maybe you've worked on these cases. It's really hard for a number of reasons. One is a judgment by the Supreme Court in the Nunn case about 10 years ago more or less stopped post-conviction disclosure. What does that mean? It means that if you get convicted and after conviction you want to access some of the exhibits or some of the documents that led to your conviction, broadly you're not able to. There are exceptions, there are other ways, but broadly that is finished now. So in American documentaries you may have seen where defense lawyers get access to the murder weapon, and then they find fresh DNA, and then they quash the conviction. That really, it can happen in this country, but it's really difficult. Because the people who control access to these exhibits are the police. And the police are very unlikely to give you access to items that may undermine the conviction. The only way to do it is to access the CCRC, and as you can see, the CCRC will reject 99% of applications. So it's very difficult. Legal aid is almost non-existent post-conviction, and also, you may know this, but a lot of people don't know this, they also destroy court records in this country, which is, I think, utterly bizarre. So since 2011, most court transcripts, so this is a record of actually what was said in court. Court transcripts have been recorded on digitally, so they are effectively digital copies of transcripts available since 2011. The expectation was, because it was no longer a storage issue, that these would be permanently held, but, and never really been able to get to the bottom of it, but the decision was made to destroy them. So what happens, this is just a screen grab of the record retention schedule. And you can see here that recording of trials in Crown courts are kept for 7 years and then destroyed. So we are completely out of step with most other jurisdictions. Most places will keep these records permanently. In America, my understanding is that the defendant will get a full copy of their court transcripts for free. That's my understanding. In this country, we destroy them. And now that the copies, you could understand there might be an argument in the past because the physical storage of these items might have been pretty problematic. But now that they are digital, there doesn't seem to be any particular reason to destroy these anymore. If you do try to get access to the court transcripts before that 7 years, it is enormously expensive. So one MP, David Davis, tried to get a hold of transcripts, the full transcripts of the Lucy Letby case, and he was quoted 100 grand. So he did knock that down from there. But typically they will be, court transcripts will be up to maybe 10,000, but sometimes stretching up to 20, depending. So lots of victims recently have been campaigning or advocating for this to be changed because a lot of victims want to have copies of the transcripts, or for various reasons. Because this is very very expensive and very difficult. And if you are a victim of miscarriage of justice, again, this is going to be pretty onerous. This is a case study, so this is one of the cases that I worked on. We applied for access to the transcripts of the case. And you can see here that this is what we were told, heavily redacted email. This is what we're told. I'm sorry that all the case files have been destroyed. You are too late, they're all gone. So we were left, because we were trying to prepare an application to the CCRC, we were seeking a fresh appeal in the case. We had to rely on court reporting by local papers and the Press Association. So this is just a number of screen grabs from the case. So in order to find out what had happened, we had to rely on court reporting because we had no idea. So you've got some statements, but what somebody says in a statement and what somebody says in court, I think you know it's very different, substantially different. Sometimes you'll have no statements and a significant witness will give testimony in court, and unless you've got a copy, you just don't know what's happened. So effectively, you don't know what has convicted your client. So this is why I've said that the court reporting has provided a safety net for people trying to challenge their cases, trying to challenge their convictions, because the state destroys all records. So you cannot get access to your exhibits broadly, and you cannot, if you leave it too long, get access to the record of the trial that convicted you. So these court records just go down the memory hole. So I was just looking around the National Archive, and the National Archive tells you that you can access court records back to the 16th century. I haven't looked, and I reckon they're a bit sketchy in the 16th century. But I tell you something, they're probably more substantial, and they actually exist rather than more recent cases. But, so any case 7 years back, so anything before 2018, unless somebody has paid for that transcript, it is now gone. It is now wiped from the memory, wiped from the collective memory, as if it is a secret trial that there's nobody. So if you're trying to challenge a miscarriage of justice, and miscarriages of justice take a very long time to come to a resolution. So there was a recent case, the Peter Sullivan case. He was in prison for 38 years. And this is not unusual. A lot of cases take a very long time before they finally find justice. So if you are working on these cases, and sometimes somebody in my position, when you do get a case, it will come way down the line. They will have failed in appeal, they will have failed in a CCRC application, and when I get it, it's past the 7 years. And so we don't have anything, we have nothing. And what we're left with, and what appeal lawyers are left with, is searching through the newspaper articles, searching through the copies of what was done, and this happens all the time. But so if it wasn't for court reporters, if it wasn't for the cases that have been published thanks to court reporters, there would literally be no record of these trials at all, which some people might say is fine. But if you're sitting in a Category A prison trying to challenge your murder conviction, this is very, very, very difficult, because you might say, well, okay, you don't have the records, but you can go to the police and try to get the documents from them. Good luck with that. So it just means that this is, I'm more or less praising court reporters and thanking them, because they have been absolutely invaluable to us. But I would like, if we didn't have to use these, it would be much better if we did have access to transcripts. I don't see why we don't. Just a final note, I am chasing this up because there is a sort of a hint that the new government might be considering changing this, and I am sort of chasing them with FOIs, but I haven't quite got to the bottom of it yet.
Great.
Thank you very much.
Thank you. Great stuff. Thanks, Brian. Right, I'm really pleased to welcome the last speaker in this session. And Amanda's joining us from a PhD student from Cardiff. So, Amanda Hill.
Thank you. So, good morning, everyone, and thanks, Richard, for inviting me to speak. I'm going to present the key findings for part of a research project I carried out late last year. And the project was funded by Cardiff University and supported by the Open Justice Court of Protection Project, also known as OJ COP. So the whole project was about transparency generally in the Court of Protection, but today I'm going to focus on reporting restrictions. And I'll do a brief introduction of the Court of Protection and OJ COP, and then go on to my findings. So the Court of Protection is a court that makes decisions in the best interests of people called the protected party, otherwise known as P, who lack the capacity to make those decisions for themselves. And this is due to an impairment in the mind or brain, like dementia, a brain injury, or a learning disability. And the court makes decisions about specific issues, such as where somebody lives, the care they receive, who they have contact with, medical treatment, internet use, etc., etc. So before 2016, hearings were held in private to protect P's privacy. Because of the lack of transparency, the court had a very negative reputation, as shown by these images of the type of media coverage of those years. So there was major campaigning by newspapers for the court to improve transparency, and the judiciary responded to that. So after a transparency pilot in 2016, COP hearings generally became open to the public, so anyone could go along to a courtroom and observe a hearing in person. The pilot then became standard practice until the pandemic hit in 2020, and Charles already referred to that. So after lockdown, all hearings moved online and became remote hearings. And initially, these weren't open to the public. So this sparked the setting up of the Open Justice Court of Protection project. So, and as Celia's in the room, and she's already been mentioned, I feel I should say it's set up by Celia Kitzinger and Jill Loomsquin. So OJ COP is run by 5 members, of which I'm one, and we're all voluntary, we're not journalists or lawyers, and it's an independent organisation, and it's not linked to any institution, including the Court of Protection, and it's completely unfunded. So its aim is to support the judicial aspiration for transparency, and we do this by supporting members of the public to observe court hearings, and we also publish blogs. So the situation now is that hearings are back in person, but there are still a lot of remote hearings as well. So I would add that in OJ COP's experience, it's very rare to see journalists in Court of Protection hearings. So the public are allowed to observe COP hearings, subject to reporting restrictions, which are set out in a transparency order. So a TO is made at the beginning of a case, and it applies to future hearings unless anybody applies to change it. So observers should receive a TO for every hearing that they observe, so they know what they can say or report about a hearing. So the standard template TO prevents any identification of P and their family, but it doesn't prevent the identification of the public body in the case, and it doesn't prevent identification of professionals. So the screenshot that I've put up here shows the penal notice of a TO, and there can be severe consequences for getting it wrong. So it looks scary, it's all in capitals, and members of the public are alarmed by it, and it's intended to alarm us. The court wants people to comply with reporting restrictions. So anyone affected by a TO can apply to have it varied or discharged, including observers and journalists. So as to how long a TO should remain in force, the standard TO contains 3 options: until further order of the court, until the death of P, or for some period after the death of P. So that's the background, and now I'll turn to the findings from my research project. So a group of people associated with OJ COP observed 32 COP hearings from the 1st of September to the 31st of October 2024, and we received TOs for all of the 32 hearings. And I'm going to outline 5 key findings. So one of the TOs allowed the P in the case to be named, which is really unusual, but it's a good thing for transparency. And the P was Tony Hickmott, whose situation has been extensively highlighted in the media. And I observed a hearing concerning Tony in October. And the reason Tony can be identified is that in 2021, one of the rare occasions when journalists covered a COP case, Sky News and the BBC successfully applied to the court to have the TO changed. And I think that example shows the value of journalists covering COP cases, especially in being able to challenge TOs. And one TO in the sample was unusual because it had extensive reporting restrictions. P was a man who, according to the published judgment about this hearing, had attitudes that are either illegal or contrary to widespread norms. I know what they are because I was in the hearing, but of course I can't tell you what they are. And there had been previous press coverage about this man before he became a P, so there was a risk that if certain information was reported, the man could be identified through jigsaw identification. And there were a whole heap of things put into the TO that we couldn't mention when we published a blog about the hearing. I've already said that the standard TO doesn't prevent naming of professionals, but actually in this sample, about a quarter, so quite a high proportion, included restrictions preventing the identification of professionals involved in the hearing, including clinicians. And there was one particular TO with a very restrictive clause. So I don't know if you can read that or not, but so this is an example from the TO, and 6C prevents identification of any doctor, nurse, healthcare professional or their family providing advice, care or treatment to the P, who was JB. So not just the professionals, extended to their family as well. So I've called that restriction creep because it's so wide-ranging. My fourth finding is about mistakes in the drafting of TOs. 28% prevented the identification of public bodies such as the local authority or the NHS Trust, and 22% included confidential information about P, whose privacy is supposed to be protected. When we queried these with the court, each time the court told us it's a mistake, and they said they'd fix it. And this shows to me the care that needs to be taken when drafting TOs. It also highlights the need for vigilance when a TO is sent by the court to an observer or a journalist to ensure that there aren't unnecessary or unintentional restrictions or information. And again, the importance for open justice of members of the public and journalists challenging TOs. My fifth finding concerns the duration of TOs. Although the standard template has 3 duration options, in practice only one is used, and that is until further order of the court. And that means the TO remains in force forever, even after P dies. If somebody wants to change the TO or have it discharged completely, they have to make a formal application to the court. And of course, that costs a lot of time and a lot of money. To conclude, there's been a lot of progress in transparency in the Court of Protection since 2016, and most of the time people observing receive a TO so that they know what they're allowed to report or say about a hearing. But there are too many errors when TOs are being drafted, and as I said, I've termed this restriction creep in terms of not being able to name professionals in reporting. I want to finish by stressing that open justice matters, and it doesn't just affect journalists and bloggers. Restrictions affect families being able to tell their cop stories. And I've included a newspaper report of a case that is still before the cop. The family went to the media recently, it was a really high-profile case, to highlight it. But they had to do so anonymously because they're impacted by the transparency order in place. Thank you very much.
That's fantastic. Thank you, Amanda. We're running a little behind time, so what I was going to say is we can start the next session in about 10 minutes at 22, so maybe a 5-minute break. But just before we do, does anyone have a question either for Amanda or indeed for Sally or Brian? Just time for one. If you are asking a question, you've got to use this very fancy piece of kit, a catch box, which is got a microphone in it, and you pick up on the live stream. So, no, it's all right. I'll run over. It's all right. Sean's given away. She didn't play rugby in school.
No, I'm really terrible at catching. I'm awful. I just actually wanted to pick up on Brian's session. It was brilliant. I'm working, as I said, working with someone who's suffered a miscarriage of justice and have covered many of them, and actually didn't really get time to get around to that bit of my speech because I was running out of time. But court reporters play a vital role in that sphere of things I've seen. I mean, I think we've probably all seen Tristan Kirk's work on the single justice procedure, and that he has uncovered a massive miscarriage of justice, which I predicted, didn't I, in your book?
You did.
I think it was the most obvious thing that would happen. But yeah, it's great to hear that you know, that it is performing that vital function, and it's just a shame about the transcript issue. I think it's crazy.
Yeah, I mean, you were obviously aware of that.
Chuck it to Brian. Go on.
Sorry.
Here we go. There you go.
So, I'm guessing that you were already aware of the issue with destroying transcripts, yeah. I mean, I'm trying to chase it up and try to find out, because there seems to be suggestions that they're going to change this, because there's really no reason. There's literally no reason at all.
There used to be when they had to tape over the when they had to like literally record over the tapes for space. But there's no excuse now, so no, good work on it. I hope it does change.
Yeah, I hope so. But yeah, I mean, court reporters have been absolutely vital. And if you talk to any criminal appeal lawyer, they are just, that's what they rely on now, because most of these miscarriage cases take so long that, yeah, there's no other way.
And also just highlighting them in the media is really important. So all the work that Emily Dugan did on Andrew Malkinson's case was vital in that. And yeah, it's important, and I'm glad it's working.
Brilliant.
Great stuff. Thank you. Go on, chuck it. Come on. You can throw it. Yes. Right, there you go. Right, we'll reconvene at 22 for the next session. So just time to have a comfort break and all the rest of it. And you can ask the speakers to kind of come forward and got your presentations ready. Great stuff. Thanks very much.
capacity, I'd like to say a big word of thanks and congratulations to Richard on bringing together this important conference. And it's great to see scholars and practitioners working together and debating together on something that we don't know enough about, certainly from an academic perspective. So great session in prospect here right now. 4 fantastic papers. I'm going to keep my mouth shut as much as possible. Not an easy thing for me to do. And hand over to Barney Chowdhury from the University of East Anglia, who's going to talk to us about change-led solutions-based journalism.
And I've got 12 minutes starting from now, and I apologise because there might be some swear words that come into it, but I've got academic freedoms, my lord. So this is what the title is, but we're going to really dumb it down, because what I think it's about is this. I'm going to say something. Full disclosure, I hate judges. Black and white, I can't stand them. I want to talk to you about a case that happened recently. An 80-year-old South Asian pensioner was kicked to death in Leicester. And as he was being kicked to death by a teenager, another 12-year-old was filming it for 7.5 minutes, while encouraging and goading the other teenager to carry on kicking him, and using the P word at the same time. The judge decided that it was not a racially motivated attack. Nikki Campbell invited me onto the programme, and lovely, wonderful 5 Live wanted me on for 10 minutes. I lasted the whole hour, giving my spurious thoughts on what I thought about the world, the life, the universe, and the meaning of life at 42. And then on comes a KC.
I think the public need to recognise that this judge is a very senior judge, and he was constrained by the law. It doesn't mean that he didn't want to lock her up.
But it doesn't mean he didn't get it wrong either. It doesn't mean he didn't get it wrong either.
Well, it does mean that he didn't get it wrong, because, as I've said...
No, because the appeal, that will be for the appeal courts to decide, surely. That will be for the inquiry to decide. Judges get it wrong.
Well, no, I'm not suggesting judges don't get it wrong. I'm not suggesting that for a moment. And judges, I know many, many judges, and judges accept that they get it wrong. But in terms of any suspicion that this girl had previously offended, that would not be sufficient to qualify her as a persistent offender, because nothing had been proved. So the judge could not send her to custody because of her previous good character in terms of her record. However, I'm not suggesting that law shouldn't be reformed in that respect and that element be removed. I'm simply here to identify the legal framework, and I know that may cause
and I'm arguing,
as it stands.
And I'm arguing, I'm saying that the words out the mouth to say that it was not a racially motivated attack was erroneous.
Well, that could be. So that could be correct. I'm not to defend the utterance of those words. I am simply pointing out that the judge tried the case and formed a view on the evidence. That is the judge's role. The judge was there, the judge heard the evidence, and the judge reached that conclusion.
But when a judge...
That is the reality of the situation.
Jeremy, when a judge says bold-facedly that this was not a racially motivated attack, that means that he's already prejudged the situation into what he can sentence.
I think the public need to
So here's why I don't like judges. I was phoned up by a judge in 2020, and they were on the phone and they were crying to me. They were telling me how toxic the judiciary is if you're a person of colour, if you're female. And I thought, yeah, okay, fine. I think I've got a story here, but you're going to have to give me more, please. I need to verify this. I need some other independence. So they put me in touch with 2 more judges, who put me in touch with 2 more judges, who put me in touch with 2 more judges who were telling me the same story over and over again. One of them told me how they were pinned up against the wall by a senior judge and was told in no uncertain words that if you don't listen to what I'm telling you and how I direct you, you're not going to last here at all. And so I published a story. And I went to the judiciary for a right of response, went to the Lord Chancellor's office for a right of response, managed to get a person from the Justice Select Committee to talk to me on the record, and I published my story. The moment I published my story, the Office for the Lord Chief Justice got in touch with me and said, hand over your sources. To which I said, thank you very much. And they were in an absolute state of denial. They said, we're not toxic, we're not misogynistic, we're not racist, of course we're not. We're good people. And I went, yes, of course you are. And as a result of my persistence and reporting and highlighting the cases, the judiciary decided to set up a whistleblowing committee in July 2021. But there's a big problem here. The person who should have been on that committee was a woman called Judge Claire Gillam. And Claire took the Ministry of Justice to court, and after a 6-year battle, won on the grounds that the judiciary was racist, was misogynistic, was a bullying atmosphere. And they refused to put her on that whistleblowing committee. So I wrote a story, and a couple of days later, Claire Gillam was put on the whistleblowing committee. It's wonderful, the power of Eastern Eye, a really small South Asian national newspaper. And I'll come on to it in a second. But so some judges wrote anonymously to the Media Select Committee and put my papers, put my articles to them. And Lord Cucker, who was the chair of the Judicial Appointments Commission, went, I'm really sorry to hear all this. I will investigate it. And of course, nothing happened. In the meantime, judges set up their own union for the first time, so they're now represented by a union. The second thing that they did was to set up a judges support network, which allows them to help each other out. And some journalists have decided to introduce that, which I find unedifying. What did I uncover in July 2021, which was so important? I had leaked to me a document which showed how judges were being taught to diss candidates and judges applying for promotion. They were actually being told how to do it, and you would never be caught if you did that. So it's along the lines of, I don't like Kester, I've never met him in my life, but I'm going to diss him anyway because his face just doesn't fit. And as a result of that, Kester is going to be blackballed all the way through. And we've been fighting for that transparency ever since. And one judge did that. And also, so did a solicitor as well. And it just struck to me, how much money were the JAC spending on defending the cases of complaints? In one case, for a 2-day hearing, they spent £101,000 on one case. And that case is still going on. And they're throwing good money after bad. A judge decided to take the JAC and the ICO to court, and is still in the middle of trying to find out information. One of them is about the Freedom of Information Act, Section 36, which says that if we decide something, we must be allowed to discuss it in private and make sure that nobody else hears about it. So what goes on tour stays on tour. That's their philosophy. I challenged that in the upper tribunal. In the first tier tribunal, I had to find a barrister who'd help me, and the judge, who wasn't particularly bright, decided in my favour on 2 of the points. We're appealing that for the other 8. The JAC have appealed, and now there's a standoff. And the JAC are unwilling to hand over information, which I think should be in the public domain in terms of open justice. It keeps on stretching the deadline, and the ICO, ineffective as it is, are sort of going along with them. I've put in another Freedom of Information request, and have written 23 stories in the past 5 years about the Judicial Appointments Commission and the judiciary and how awful I think it is. They don't like me, which is fine. I don't know why. I'm a nice bloke. I really am. But I'm a bit of a pugilist when it comes to openness and transparency. And I just think that we, as an industry, we as academics, have to keep on fighting the good fight. Because I think Sian's absolutely right. There is creep going on where we are being told we can't have this, we can't have that. And it's up to us to make sure that we hold those judges, hold the people who make those decisions to account. And it's up to us as academics to teach our students to do that as well. That's it.
Thanks a lot, Barney. We've got some time for maybe a quick question or comment, if there was one, if there are any. And do some catching.
Whoa, there was a real gasp there. That was great.
First person on the team sheet.
Where do I speak to? Into the black circle. Good. I work here at the University of Salford. My name is Mike Beckman. I just wanted to ask you, how much of your fight is about proving that this is systemic, institutional, pervasive, or is it just concentrating on the bad eggs?
No, it's definitely systemic, it's definitely structural, it's definitely institutional. I think that because they think they are above the law, that they will continue to do this.
Who do I throw it back to?
Ex-Gaelic footballer. Emphasis on the word ex. Okay, folks, we're good to go now. So next
I'll let you,
paper-
if you can. It should be up here. Let me see. Let's see. It's Rachel's one. There you are.
Oh, there we
So
go.
our next paper, folks, is from Kester Demmer from the University of Leicester, focusing on an actor network accountability Philpott trial. So over to you, Kester.
Thank you ever so much. Good morning, and thank you ever so much for accepting the paper. For 30 years, I worked as a journalist for BBC and ITV. That's how I know Barney. We get on so well. Mainly in regional television. And obviously for regional television, court reporting is a sort of a bread and butter activity. It's certainly when it comes to big stories. And obviously I want to talk about one of the biggest stories that I was involved in as a producer. And that's the Philpott trial, which you may all remember. 11th of May, 2012. It doesn't look that bad, does it, this house? But inside that house, 5 children died. The shocking thing was that the fire was started, probably, before they were convicted, by the parents. They're the poor kids. 5 died in the fire and 1 died subsequently afterwards. Mick Philpott, Mairead, and his friend Paul Mosley. Mick was very well known to us. He was a local character. He'd been on TV. He'd been with Anne Widdecombe doing one of those exchange-type programmes. He had a reputation for being violent, but also being very promiscuous. Horrifically, on the night of the fire, the 3 of them were all engaged in intercourse. And when the police put them up in the hotel down the road that evening, they continued their goings-on, as it were. Rather unpleasant character, obviously, as the court report, the court was to find out. What's interesting about this story is it happened quite soon after this. Obviously, I'm going back a long time now. Twitter was new. In fact, I had to roll Twitter out for the BBC in the East Midlands. I was given 6 iPhone 5s, and I had to see every tweet before it was tweeted. You can imagine how long that lasted. Yeah? This is the BBC. Regions were really slow on the uptake because it was the BBC. We weren't allowed to do it. So as I say, I had to have a phone, and then 5 selected reporters were given the privilege of being able to tweet under our banner. This changed the way we did court reporting, obviously. We were allowed to broadcast live from inside a courtroom. It seems very matter of fact now, but at the time, it was huge. And our first big test was the Philpott trial. I've done research using what's called actor network theory. Yeah, it's based on Latour, on Callan, and Law, three academics who, back in the 1970s, started looking at the way networks were built. It goes against that idea of things existing outside of networks. So, for example, if you have a phone, and you have Twitter, and you have a reporter, you've created a network of three beings. Individually, they're quite different. You have a camera crew. You have, sorry, I probably needed to move this on. I won't bother explaining this to you because it's rather, well, it's French philosophy. And it hurt my brain when I had to do the research and had to read up about it. But basically, the main important thing to understand is it claims societies cannot be properly explained unless we understand the connections between societies. So central to this idea is that human and non-human actors can come together to form identities, yeah? And that they have an equal part to play. As we saw just a moment ago, camera crew, sorry, plenty of criticism, sorry, I meant to quickly go through this. It's being condemned by a lot of people, but it's now being used an awful lot as a way of understanding and explaining society rather than sort of preconceived ideas. I like the fact that actually it wants us to look at what happens in practice, not retrofitting why things were done. For example, news values that we use to sort of slice things apart. Look at what's happened. Actor network theory requires you to actually watch and observe and see what's being enrolled. What actors are being enrolled to form that network? So in the case of our reporter, it's a phone, it's Twitter. We have a journalist, we have a camera, we have a camera crew. Separately, we have a journalist. Separately, we have a camera. Bring them together, they create a new being, a new network. Camera is made up of bits of plastic, it's made up of bits of metal, it's made up of bits of wire, etc. Humans are made up of all sorts of complicated chemicals. They are also networks, okay? So simple understanding of bringing them together creates a network. When the camera's turned off, the network is broken. There's no stability. And that's what's core about networks. They have to constantly be remaking themselves to actually remain stable. For example, if you take something like a diesel engine, which Latour uses as an example, it chugs along quite nicely and will continue to do so. But if you don't maintain it, if you don't keep it stable, it will break down. When a piston rod goes, your network is broken. Same is true of this. If the camera breaks, the network breaks. Yep, very straight. That's a sort of a diluted look at actor network theory. A more complex network, for example, and this is one that I designed for actually a broadcast of the same program. If you look, you can see all the different elements, or some of the different elements, that go into creating a live outside broadcast. Elements in Birmingham, elements in Derby, transmitted program. All of these are members of that network that were created to create that program we did on the first day of the fire. Each one of those networks, again, is made up of other smaller networks. When it came to the trial, thank you, Helen, one of the best court artists, I think, in the country, without a shadow of a doubt. Simon Hare, our reporter, sat throughout the entire trial. He was one of only a few reporters who were allowed in every single day. And as we've seen, he was allowed to tweet. It's completely changed the dynamics of court reporting and of reporting generally. It changed the line of, thank you very much, it changed the line of command. It changed editorial oversight. It changed what he could do. It changed what I could do as his editor. I was no longer part of his network. He created his own network of what was going on in court. So as he sat there in court, let's have a look what the next one is. As he sat there in court, he was using what he was hearing. He was using Twitter, he was using his iPhone 5, and he was connecting his, creating his own network without the rest of the BBC. So, he is the focal actor. He enrolls other people into his network and those people who are following him. So they're either following his hashtag, they're following his Twitter feed. I'm afraid that's quite an old picture of Simon, as Barney well knows. So, he's sitting in court in Nottingham, he's watching what's going on, he's using his phone, he's using Twitter, and people are receiving his information. What he's doing is going directly to his audience. He's not having to wait for 6:25, he's not having to wait for his little slot. He was tweeting, 12, 13, 14, 15 times a day. He was doing all of this on his own without sort of any fear of interruption. But what it meant was he was enrolling other people, and he was having to come to terms with what that meant for his journalism, because he was getting people asking questions. He was getting people making comments like, they're guilty bastards, etc., etc., etc. They deserve to be hung, da-da-da-da-da-da. And of course, he was having to step back from that social media interaction and go back to just being a journalist. So loads of examples like that that you can find. And this is what's quite interestingly. He had to make sure he didn't get sucked in to that sort of, oh yeah, he looks shifty to me kind of stuff. He had to remember that he was still a reporter. It's like when my daughter sees something ping on her phone and she must pick it up and she must respond straight away. And I say, no, just think a little bit before you do it. You don't have to respond straight away. And that's what happens. So he was having to permanently try and avoid doing that. More interaction, dead straightforward, as you can see. These are some of the more shareable ones. And this is quite interesting. He was so busy having to write his court report for the evening that he had to apologise that he couldn't do it. So his stability of his network broke down. He was no longer able to tweet because he was having to do his day job as a court reporter preparing for his 6:25 live into the programme. Bang, guilty, there we go. So, to sum, what this gave us was a way of circumventing our linear transmission times. Real information in real time. Didn't have to have satellite trucks, didn't have to have television masts, didn't have to have all of the millions of pounds that goes into broadcasting. He becomes his own publisher, as we all know. He no longer had anyone, no second pair of eyes overlooking what he did. So that's dangerous in itself. Fortunately, he's a very, very experienced court reporter. As a producer, that meant he was rogue as far as I was concerned, and so I have to rein him back in so he could do the stuff I want him to do. So it's changed the way we acted completely. Now, this is obviously bread and butter now for everybody who reports from courts, but it's just an insight, one example of how by applying actor network theory and mapping his location within the network, we can see how that network grows, how that network stability is created. If you want to know more about Latour and Callan and law, I'm happy to try and explain it. My retention of it is limited these days, having written this some time ago. But it's a way, I think, of getting us to look at what is produced rather than using news values as we assume them to be. Yeah? Look at journalism as practice. What is being done, by whom, and to whom and how, as opposed to retro trying to fit it. Thank you ever so much.
Thanks very much indeed, Castor. We have time for a quick comment or question. Thanks,
Richard.
Two of you, please, yourself first. This is what's known as the conch from now on.
That was absolutely fascinating. The great thing about that piece of legislation that you put up at the beginning was that it didn't just apply to journalists.
Absolutely.
There's actually something in it that says, so can members of the public as long as you ask the judge.
Yeah.
And we were the first people, my sister and I, to tweet live from the Court of Protection, which was a few years later than you did it in 2017. So we posted a photograph of ourselves outside the Royal Courts of Justice saying, we don't know whether we'll be allowed to tweet when we go into this hearing, but we'd really like to and we'll let you know. We got in, we asked the judge, he said yes. So she and I started tweeting. Of course, we didn't have an editor. We were just members of the public doing it. But everything that you said applied, you know, dealing with comments, dealing with queries. And it was a hearing about treatment withdrawal. And we had a sister for whom we wanted treatment withdrawal. So we were deeply personally involved in that case. So it was a very different scenario. But I think the issues of how tweeting, and it's so sad it's all dead now, but or damaged, but how that kind of instant mode of communication both changed professional journalism, but also changed court reporting for those of us inside the courtroom at the time who are not journalists.
No, absolutely. I mean, it was a you know, those social media apps are defining moments that led to, you know, the citizen journalism, you know, live citizen journalism in that respect. Yeah.
So I'm Richard Danbury and I kind of at City, but it was just identifying a bit of your network. It was a very interesting analysis, which is implicit in what you're saying, but wasn't on one of the boxes. And that's the intellectual capacity, knowledge of media law, knowledge of what to do so it doesn't go pear-shaped quite quickly. Because we all know tweeting from court is quite dangerous if you don't report fair accurately and contemporaneously. There was a famous case of Sky who reported the prosecution's opening and then fucked off.
And I think sadly we see more of that. It's that instant knee-jerk reaction of must be first, must do this. And as you say, we should be balanced. We should be giving openings. We should be going back. I mean, I remember having to remind fellow producers that they had to go back. Oh no, we've done the opening. Yeah, well that's fantastic. But if you don't want the editor to go to jail, then maybe we should go and see the defence. And I think because of social media, we've completely changed. I say we, old lags like me still respect the law in that sense. But I think there's certainly a lack of understanding amongst the public about what can be said. Obviously, because it's an absolute free-for-all bun fight. But yes, you know, you've still got to stick within the rules. Which I think some people find very hard. I mean, a BBC journalist I won't mention, who's still on air, only now does live reports looking back at his tweets. So there you go, that'll tell you the gender. I still like to see reporters with notepads writing proper, you know, shorthand, and then going to do their notes. But I say, I'm an old man.
Thank you, Kester. I'm afraid we're going to have to move on. Maybe you could have a word with Kester at lunch. Actor network theory, artificial intelligence on autonomous agents is something I've been thinking about. I wonder.
There's a lot of work.
I think there's a lot of work to be done on that. So absolutely fascinating. Thanks so much, Kester. So next paper, folks, is from one of my great colleagues in the journalism team at Salford, Rachel Howarth, who's going to talk to us about pressures on contempt of court in the social media age. Over to you, Rachel.
I am hoping that this will kind of resonate with quite a few of us in here. It's something that I have had an interest in for quite some time, as a journalist and also now as an academic. It's something that I kind of noticed quite a lot when I was news editor, and I've had kind of quite a few discussions about. Now, I have like oodles and oodles of context here, which I'm going to try and cram into kind of 12 minutes. But looking around the room and kind of seeing everyone who's here, I might not need to go into that much detail about it, so I'll just kind of give you a bit of an overview. So I'm kind of looking at, is a lack of social media regulation resulting in pressures on court reporting, and trying to get some answers from journalists, essentially, who are still working in the field. Now, as we all know, journalism courses across the country are obviously kind of still really promoting media law. It is something that is incredibly important for journalists going into the newsroom. So crucial is it that it is a kind of core component of the NCTJ and for BJTC accredited courses too. So one core facet of media law taught in this is obviously Contempt of Court Act 1981, something that we're all kind of really familiar with. And arguably, the most important aspect for journalists is the strict liability rule, which obviously applies only to publications, of which there are kind of many listed. But to date, the Act does not refer explicitly to social media, despite several revisions. So until the advent of social media, publishers were somewhat kind of collectively understanding of their position in breaching the strict liability rule. Obviously, this doesn't mean that breaches didn't occur. We can all think of kind of cases where publications have been in contempt, you know, naming the kind of Joanna Yeats murder and the arrest of Christopher Jeffries, probably the one that's bandied about the most, the one that we all kind of know about. But for most journalists, especially those covering the court, the Contempt of Court Act is a non-negotiable element of the job. It's one that is understood from the start and that does not present much room for manoeuvre. However, and this is something, like I said, that I have picked up on, while occasionally lay people have been brought to justice for kind of breaching it, something I intend to cover in greater depth as I kind of go into this. I want to look at kind of how often this actually happens. How often are people actually being pulled up for their behaviour on social media? Publishers are still being held to standards that many on social media are not. And it kind of can be really frustrating as a journalist when people are demanding, why are you hiding this? Why aren't you telling the truth? You're lying, mainstream media lying, and that's something that you'll see a lot, and it's because people don't really understand what they can and can't say. So while many in industry have heard editors sharing horror stories amongst themselves of breaches of the Act and tales being kind of brought before a judge or having to like really quickly bring something down that they may have spotted, users of Facebook and X seem to be kind of posting with reckless abandon, with no knowledge or no concern about the Act and its repercussions on the kind of criminal justice process. So in recent months, there has been increased focus on the Contempt of Court Act, and this is in large part due to the Southport murders and the kind of information vacuum that was created by the strict liability rule, so things that couldn't be said, which then allowed for people to essentially jump in and fill those gaps. This is something that the Law Commission has kind of recognised, and it's set to publish the first part of its report on the Act in autumn. It does suggest that the widespread disorder which ensued was an indirect result of the Contempt Act. Moreover, it has at times, sorry, I think I've just realised that I've not been using my slides. Apologies. It has at times, it's called the Law of Contempt disorganised, and it's called incoherent. And despite this, it is said that its suggestions will lie largely in line with what already exists. So I don't think there's going to be many suggestions to change that from what I could kind of tell from reading through that. Sean's nodding, which is filling me with confidence. So this study that I'm doing aims to establish whether the lack of policing on social media is having an impact on the way that publications operate when they're covering court, and if anything can be done at all to kind of rectify this and make it easier, essentially, for journalists to combat this. I'm carrying out a series of kind of semi-structured interviews. I'm hoping to do around 10. I've so far only done 3. And I'm also hoping to share an open question survey on social media, particularly into local groups where a lot of this kind of behaviour occurs, to establish what people actually know about the law and, you know, how that's kind of impacting their behaviour online. So the first thing that I have found, I'm going to share kind of some of the things that I've found. The kind of main thing that jumped out at me was the mitigation that journalists are having to do to kind of monitor other people's behaviour online. So like I said, this is all based on kind of interviews that I've done. So the journalists that I did speak to agreed that one of the main problems is the mitigation. So while direct liability for comments made by others isn't automatic, publishers do have an obligation to manage the comments on their websites and social media pages. So before Facebook allowed social media managers to actually turn the comments off, especially in high-profile cases, this was a really time-consuming thing. I'm looking at people around the room who I know might have had to deal with this. So turning off the comments, monitoring comments, removing comments, things like that. This problem is emphasised even more on X, Twitter, whatever you want to call it, where the moderation of comments is more difficult as it's kind of harder to switch them off. It's a bit more of a Wild West. So one editor gave the example of the trial of Lindsay Birbeck's murderer, which was a young lad called Rocky Marciano Price. So Miss Birbeck was a mum of 2. And she was murdered in Accrington in 2019. That was a patch I was covering at the time, so I remember it well. The defendant was obviously not named by any publications covering it at the time. There were quite a few publications covering it at the time because the defendant was 16 years old. The editor in question that I spoke to recalls that his organisation's website, along with other regional websites, were being monitored by the police to make sure that nobody was commenting underneath. And at some point, somebody actually named the defendant underneath in the comment section, and within 30 seconds, this editor had a phone call off the police saying you need to take it down immediately. It had barely been on there at all. And what had happened there is somebody had actually gone into the courtroom, which anyone can do. They'd seen the name of the defendant, and then they'd published it themselves online, and it was being shared widely. So, yes, a bit of a problem. So there's a kind of general feeling that the strict contempt rules and the expectation of responsible organisations to limit the opportunity for someone else to commit contempt also influences how the news is shared. So all 3 of these journalists talked about kind of the impact that this has on engagement. Obviously, if you're having to turn off comments and you can't share your work anywhere, that is immediately going to have kind of a big impact on how many people are reading it. And a couple of the court reporters that I spoke to did talk about the significant difference between their page views and the people who were kind of reporting on live news, who might get kind of, a regional website, maybe 1 million page views a month, compared to kind of, maybe even quarter of that. So that was kind of a big issue, really, that was raised, that was brought up, like a theme that was brought up quite a lot. The editor in the Lindsay Birbeck case had actually launched his own social media page specifically for court news, where all the comments at that time could be turned off. So it made it a little bit easier. The mitigation wasn't as difficult. But again, you're only targeting a really specific audience who've actually joined that Facebook page because they want to know about court news. So it's not reaching anyone in the kind of wider, the general public in the kind of wider sphere. As I said, there was a reporter who talked about their page views often being lower, but they did say that there was no punitive measures towards them, even in newsrooms where page views are kind of monitored. So that's one thing, is the mitigation. The second thing is education. So there is a general feeling that more could be done to educate kind of lay people, the public, on contempt of court and the strict liability rule. But the general consensus is that there is no obvious way of actually doing this to make any real impact. So in 2021, the Attorney General ran a campaign to educate social media users on the risk of committing contempt with social media posts. It was called #ThinkBeforeYouPost. This lasted for 5 days. And there was no kind of published results. You have no idea who's that has reached. There wasn't much engagement on social media, so there's kind of questions over how successful that is. The Law Commission has said in its kind of preliminary findings that it's difficult for lay people to understand and identify the relevant law. Thank you. Okay, so yes, that is a major problem. The education is a major problem. Journalists occasionally do their own education, but it's hard to quantify how well this is received. Sometimes they will publish articles during high-profile cases that explain this is what we can report and this is what we can't. But other than kind of looking at the page views, there's no way of knowing if that information has actually gone in. And another issue that was raised is trial by social media and how people can be educated about that. It is considered a real problem, and there are particular high-profile cases, such as Lucy Letby, where discussions of guilt were really prolific during the trial, but now discussions of innocence are even more so after the conviction. And the final point that I want to make is about policing. So all of the journalists also agreed that better policing of social media accounts themselves would be helpful in kind of reducing some of this behaviour. The Law Commission consultation paper has already stated that many courts and tribunals lack any meaningful powers to deal with contempt. Now, there are cases where some social media users have been prosecuted. It is rare, but it has happened. In 2018, a woman was found in contempt and given a suspended sentence and a £2,000 fine after posting videos and photos from court alongside posts naming witnesses and suggesting they were guilty. In 2019, I don't know if you know Tina Malone, I should have put a picture of her up, she was in Shameless, it was quite a well-known thing. A victory for us all. So she's quite well known. She was given an 8-month suspended sentence for sharing images that were supposedly of John Venables, who's the killer of toddler James Bulger, despite claiming that she was completely unaware that there was a court order in place. She did ultimately plead guilty and she was fined £10,000, presumably because of her high profile, like kind of the nature of who she is, as well as being handed a custodial sentence. There was one more case that kind of jumped out at me, and this one I find the most interesting. I have run out of time, so I'll wrap this up quite quickly. There was a case of a woman called Angela Wrightson who was murdered. That had to be delayed. It had to be postponed because essentially hundreds of people on social media started naming the teenage defendants who were only 15 at the time. So that had to be kind of put back. And that cost the public tens of thousands of pounds. So essentially, it is a problem. It isn't incredibly well policed. There needs to be more education, but we aren't really sure at the minute how. So my next steps are, I'm going to do some more interviews. I've got some surveys to send out, and I kind of also want to look at, does it depend on how high profile the person is who's making the comments on social media? Because I think that has a big thing to do with it. As a juror, are you going to really care if you see kind of one person who you don't know saying, oh, they're definitely guilty? So that does play into it as well. The general consensus is that court reporting is an important part of the judicial process. It must be protected, and journalists must be allowed to carry on their jobs without having to do too much mitigation. That's it. Thank you.
That was great. Super. Thanks very much, Rachel. Time for a quick comment or question. Yes, we've got one here. Thanks. You mean the conch? Lord of the Flies, folks. You've now got the power.
Thank you. That was super interesting. Thank you. And it'd be great to talk further. But so my primary research is around news and media literacy, and you might know there's quite a lot of work going on in that space at the moment with the curriculum review, and there's a House of Lords inquiry into media literacy at the moment. And this is something that Maria, who's here, and I have been talking about as well. You know, in the immediate run up to what we thought was going to be the trial of Axel Rudder-Cabana, and the conceivable specific misinformation issues that might, that would occur during the course of that trial. One of them being around trying to explain to people what they weren't seeing in the mainstream media and why, when there was likely to be, a huge kind of swirl of miss and dis. Well, now that trial didn't happen, but that sort of started some conversations around the kind of what could be done to utilise what is actually quite a big sector of news literacy organisations and projects that are trying to educate people around this stuff, to kind of respond rapidly to sort of key moments around things like high profile trials, and utilise like the resources that they're doing, get them out through their teaching network, things like that. And it's something that we've been thinking about quite a lot over the last few months, so it'd be great to sort of link up maybe and talk about your work.
It's interesting because the Axel Rudder-Cabana thing was something that was brought up quite a bit.
Yeah.
I did actually speak to a journalist who's from Merseyside, and that was something, but it was more the misinformation that was being spread rather than the contempt.
Yeah.
Because obviously it never got to that point, but like I say, it would have been interesting to see.
Exactly. On the eve of the trial, you were facing a situation where, the reporters who were in court are going to be able to say certain things and not able to say a lot. But meanwhile, the rest of the internet is having having a field day discussing, and the possibility of, you know, the idea that that's all a cover-up on the part of the mainstream media, that they're not saying X, Y and Z. And so what do you do to explain to people, this is why the Echo's reporting only these bits and not those? And actually, the Echo did run a good piece, you know, along those lines, and the trial never happened, but there are foreseeably going to be those kind of peak moments again of, like, how do we make sure that people, you know, it feeds into the whole wider discussion about trust in journalism and differentiating in the public mind what they see when they read, you know, professional journalism versus everything else online. So anyway, let's talk. That was a ramble rather than a question, but thank you.
Yes, thanks very much indeed. And we're going to move on now, folks.
Okay.
The last paper of the session. Another one of my great colleagues from the journalism team at the University of Salford, Debbie Manley, who's going to talk to us about, as you can see, the magistrates in the community project.
So I'll just say I haven't been doing years of research on this one. Obviously, some of you have been working on these kind of projects for a long time. We teach BJTC and NCTJ accredited courses here, and part of that teaching is taking students to court. Now, that is a picture outside Minchell Street, Crown Court, if anyone knows Manchester, not the Magistrates' Court. But I didn't have a picture on my phone that was copyright free that I could use at the Magistrates' Court. It's normally raining when we get there, so it's always wet pavements and everything. In fact, all the images on the internet seem to be wet pavements outside Manchester and Salford Magistrates' Court. They've knocked the Salford off, but it is for Salford as well, because obviously we lost a lot of courts. So there's our students outside court. They always think of the big cases at Crown Court. That is what they're all looking forward to, going to a murder case. Now, of course, we get there and it's all admin, you know, and things are delayed and that court's not open and that public gallery's locked and everything else. That's going to crop up later with Helen, access. So, everybody thinks about Crown Court, but people don't often think about the magistrates, which is a shame, because what's happening, because I'm there a lot, the magistrates are very, very keen to talk to us. So what's happening is I might get Grumpy Usher, and I think actually he's caught on to the fact that I've actually called him Grumpy Usher to my students, because he actually said the other day, he came over to talk to my students and went, I'm not that grumpy. And I thought, he's actually overheard me saying it. So I've always said, oh, we'll avoid that court because it's Grumpy Usher. Because it always makes a big issue about us going in the court, and it makes my students empty their bags to show if they've got water bottles. I mean, it's a big thing that he does every time. Anyway, when I'm in Magistrates' Court, the magistrates want to talk to us. They're really, really keen on talking to us. So Ron's been over and he's like, oh, you know, where are you from? Why are you here? Blah, blah, blah. So because I'm going in every week, sometimes twice a week, obviously the usher, who's now less grumpy than he was, a lot of them recognise me as I go in. So basically, it's not just been one magistrate coming over, it's been quite a few saying, do you know about magistrates in the community? So originally it was no, but now it's like all of them going, do you know about magistrates in the community? So obviously I'm starting to know about it. So basically, magistrates in the community, they are trying to get more engagement. They're trying to get people to go to Magistrates' Court. Not just students and journalists, but actually the general public as well. It's a big engagement initiative. They've got a website, they've got the Magistrates Association. You can find information on there. Now, Ronald Marshall, JP, he's been a magistrate since 2008, and part of this relates to the idea of magistrates being old and white and male, and he became quite fascinated by this image of magistrates and everything else. He's now deputy chair of the bench, and for Manchester and Salford there's nearly 800 magistrates there. It is down from before COVID. They have been having issues of recruitment, so this is also part of the initiative. They're having trouble recruiting magistrates. Part of it was, for those years when they didn't have as many cases, they couldn't do all the training, they couldn't get the experience and everything else. So they had to up the age limit on magistrates to 75, and then it went down again, then it's come back up again because there was an issue with a shortage of magistrates. So you know, there has been a lot of news on the backlog in the Magistrates' Court. So they want to go out and educate the public as well as, you know, try and get people into court. So they are willing to go out to universities and schools and community groups and religious groups and talk about what happens at Magistrates' Court and do mock trials. So I've had conversations, obviously not just one magistrate but several, but I've just used one as an example, with them saying, look, we'll come and talk to your students. So they do it in court where they say, would you like to ask any questions? You know, do you want to ask us questions? Do you want to talk to us? And I think our students are quite like, whoa, the magistrate's just got up and walked over to us in the public gallery and is talking to us. But yeah, they are willing to go out and talk to people about what magistrates do because they feel that there's a massive negative attitude towards magistrates on social media and within the general public, that people just don't understand Magistrates' Court. So they are willing to go out, they are willing to do mock trials, so we are talking about doing that. So it's been quite interesting hearing about this project, and you will find it online. Ron's background, he's been telling me a lot about it. I know a lot more about Ron than probably my colleagues at the moment. So he used to work for the AQA exam board, so he's very into education. He also worked at City as a steward, so he very much was dealing with antisocial behaviour, drunken. I'm not just saying it's City, other clubs are available. And obviously it does happen to United as well, because I accidentally put United on the slides first of all, and then afterwards I thought, I've just written United by accident. It was City, he was working as a steward, so he was dealing with this kind of antisocial behaviour. A lot of the kind of behaviour that ends up at Magistrates' Court. So he wanted to see what happened to all these people. And one of the things he's found since he's been working is that there hardly is ever any journalists in Magistrates' Court. It is very, very rare for them to turn up. They only ever turn up if it's a big case. So if you've got a celebrity who's making a first appearance in Magistrates' Court, the court will be rammed. So that's what happens. Every so often there'll be a big case at Manchester Crown Court and they have an overflow court at the Magistrates. And it just feels like the only time anyone's interested is if it's a celebrity or overflow from the Crown Court or whatever. He says there's very little reporting on everyday crime, the kind of crime that affects us more. So he really would like to see more court reporting in Manchester, well, obviously in magistrates' courts around the country, on everyday crime and on mitigation and the reasons for offending, because there are a lot of issues with reoffending. So he'll see someone on Saturday, he'll deal with them on Saturday morning, and they're back on Monday because they've gone out. They get banned by GMP from going into centre of Manchester, particularly Piccadilly Gardens, if anyone knows Manchester. So they're told not to go into Piccadilly Gardens, but they have to go there to get food, to get help, to check in with probation. So they're set up to fail, and this is one of the issues. But on social media, it's why did they get a slap on the wrist? Why did they get this, that and the other? So he wants people to know more about probation and rehabilitation. And he says magistrates are aiming to be fair, to listen, and to understand what's going on. And one of the things my students have been really impressed with is the fact he actually talks to defendants and say, have you got somewhere to live? Because you can't do, it's really hard to do a curfew and various other things if you don't know where they're living. So, obviously the Chris Brown case, he was on that one, if you want to look it up, that was him. But the Manchester Evening News and a lot of the media focus on sentencing and not on the things that are happening in the court. So they do these roundups, jailed this week, and that is all that gets reported, not the reasons for the decisions. There are various initiatives going on, like women's problem-solving courts, although smaller court where they ask them, like a critical friend, have you got somewhere to live, have you got this sorted, have you got that sorted? But nothing for men, and it's a lot of the time, men have issues with talking about their issues. There is a trial going on with these domestic abuse prevention orders, but they're only in certain areas. So in Greater Manchester, one of the issues at the Magistrates' Court is they can stop them doing something in Bury, but then they'll move to Stockport or Salford and carry on, because it doesn't apply then, the GMP won't actually act on it. So the fact that it's only certain areas. They have a liaison and diversion team to deal with mental health issues and complex issues, but quite often defendants won't talk about needing help. And with the backlog, it's all about time. And there's a massive rise in stalking and coercive control. This is one of the things you're seeing at the moment, aged 18 to 22, quite often, more cases. Some youngsters don't understand that sending texts and photos can break the law. And he said that this is one of the things that they need more education on, education including the way the media report on things. So he was talking about adolescence, obviously, because it's a true reflection of what youngsters are doing at the moment. So, I mean, I'd like to carry on looking at the role of magistrates, do more interviews. Obviously, it's been quite fascinating. It's fascinating for my students when they come over and talk about these things. So, they are trying to get more young and diverse people to become magistrates, and but the commitment is to 26 half-day sittings every 6 months, which is quite hard if you're working. If you're young and you've got a job, because they're volunteers. So trying to get that equality, diversity, different ages and everything else is quite a challenge. So they have produced a report about magistrates mattering. They are coping with the backlog, coping with the issues with recruitment, lots of issues with single justice procedure, cases not being prepared. You probably sat in court when they haven't got the paperwork ready. Lots of issues with tagging as well, and things in the community. So more reporting of everyday crime, and obviously adapting our resources and our assessments. I'm thinking about doing a mock trial as an assessment now, having talked about all this, to prepare our students for looking at the bigger picture, and not just, this is how it started, and this is how it ended with the sentence, but what are the other factors in between? Okay, thank you.
Thanks a lot, Debbie. Fascinating stuff. We've got a few minutes for questions and comments. Barney. Yeah, Barney.
Barney. Quick question. Talk to us more about the mock trial assessment. Really interesting.
Oh, yes. So, Ron said, right, one of the things he could do is provide, we did get him in to talk to our class, hence the picture, talking about real scenarios, obviously taking out the names. So he was talking about giving us scripts for a mock trial, so getting our students to actually do all the roles in the trial, but then because we've actually got the facts, rather than splitting them up over several courts, I might not have been in that particular court, because we've got the scripts and the facts, we were thinking of getting them to write a court report based on the mock trial. So we do get them to write about their experiences of going to court. We do that as part of the accreditation. Everything else we have they file that. But we thought we'd actually do when we do it in class, then we've all got the information when we come to marking it. So it can be, it's not like I've missed something because I wasn't in that particular room.
Why steal that?
Yeah, well, one of the issues is some of the actual courts at Manchester and Salford are very, very small in the public galleries, so there's only five seats in some of the courts. So that's another campaign that Ron's like going, right, I want men's small court, for problem solving. I want to get more seats in some of those courts, and I know which ones they are because they took out some of the seats to put a big screen in. And you go, oh, so only the family can get in those. So it's very hard, but yes, doing a mock trial with scripts where we've got some agreed facts that we can then test students on whether they can actually write a court report, getting in those key facts. So it'd be very good for preparing them for NCTJ as well, court reporting exam, because that they do write and look at court reports in that as well.
Okay, thanks, Derek. Any more for any more? Okay, so great session. Thanks so much to our speakers. 4 great papers, important topics, and it's lunchtime. So,
yeah.
Richard, have you got anything?
That's great. Biggest round of applause so far. So yeah, there's some. Thanks everyone. So there's some lunch back out there. We've got just over half an hour, so we'll start again for the next session at 1:15.